A very exciting day. I am Sally Green, Vice Chair of the Orange County Board of Commissioners, and also I'm honored to be the Program Director of the Orange County Community Remembrance Coalition, which is connected with Brian Stevenson's Equal Justice Initiative, which has the monument to lynching that some of you may have seen in Montgomery, Alabama. And so the purpose of the Orange County Community Remembrance Coalition is actually twofold. One is to raise up and remember the victims of lynching in Orange County, of which there were at least 5. The other is to bring forward that history and connect it to more recent history and current events related to race in America and in our community. And toward that end, I have a quote I want to read to you from the historian Saidiya Hartman. The stories we tell about what happened then, the correspondences we discern between today and times past, and the ethical and political states of these stories redound in the present. If slavery feels proximate rather than remote, and freedom seems increasingly elusive, this has everything to do with our own dark times. If the ghost of slavery still haunts our present, it is because we are still looking for an exit from the prison. 60 years ago on this very day, a door burst wide open out of that prison, and it was the Civil Rights Act of 1964. And we're here today to learn about that, to talk about that, to understand more about the history of it and what it means for the present. So I'm honored to represent the OCCRC here and to be with you today. Thank you.
Thank you. I also want to say welcome to you all for attending this morning's event. Now, it was in May of last year that I started thinking about this event, so May of 2023, and I reached out to several people to gauge interest. And, I'm so appreciative of the scholars, the activists, the people who are willing to give of their time and talent to engage with us publicly on these very important topics. And practically everyone that I asked said yes. And so we are here today, and I want to thank Molly Louie and the Chapel Hill Public. Molly talked about everything she said about me, I have to say about her. She's done tons of work, and this library so embraces these type of events, and we don't take that for granted. So, with that being said, I'll ask our first panel to transition to the stage, and we will get started. Just tell us what was the Civil Rights Act of 1964.
Thank you, James. Good morning, everyone.
Good morning.
On this panel of esteemed educators, James has asked me to list out and talk about the parts of the 1964 Civil Rights Act. So we'll do the best we can to keep folks awake. But I am very honored to be here with you today on this special anniversary, and in the South in particular, because political challenges in the South came too close to undermining the progress of civil rights work that led to the Civil Rights Act of 1964 and the Civil Rights Act of 1965. But I hope that political resistance in the South now can be a different kind of resistance and help move us through the challenging times we find ourselves in this state and nationally. So the 1964 Civil Rights Act was an incredible tool in the hands of community activists and grassroots groups. And there are a lot of different parts of it. I'm in fact probably not going to go through all of them, because literally one title is about miscellaneous things. So that would be perhaps a little dull, but I want to talk to you about some of the important provisions of it and where they didn't quite get us all the way there, but we either made progress or over the years have sort of slipped a little bit and need to do some work. The first part of the Civil Rights Act was to address voting rights. And one of the challenges was it did bar the unequal application of voter registration applications, but it didn't address or prohibit all of the ways in which we saw voting discrimination. And at core, it didn't get to defining voter qualifications or prohibiting limits on voter qualifications. So who gets to vote is a very powerful definition. We'll get to this, but that's in part why the work wasn't done in 1964, and we so desperately needed the Voting Rights Act that followed in 1965. Nonetheless, it was a starting point for understanding and ensuring that the path to racial equity needed to be based on a secured access to the ballot box. Then the next provision, Title II, was maybe one of the most anger-inducing ones, and people got really worked up about Title II because it was about public accommodations. And so it was about whether or not, if you were engaging in any kind of interstate commerce, so hotels, restaurants, people were moving through your facility, your public accommodation, whether it had to be open on the basis of race. And so this had a real economic impact on segregation and desegregation efforts and the civil rights movement generally. So this piece was really critically important and one of the really tense ones to get this important legislation through. Title III was about the desegregation of public education, public facilities. Title IV was about the desegregation of public education. So you might be asking yourself, weren't we there already? Didn't we need, why do we need to keep doing this? It is incredibly important for Congress, representing one United States, to pass legislation that doesn't prohibit the accident of where you were born or the accident of where you live to create access to civil rights. And so this commitment by Congress for the entire United States to desegregate public facilities and public education was incredibly important. Now, most of you all know we still have work to do. We see our schools becoming now increasingly racially segregated, high poverty schools, well-to-do schools. The intersection between class and race is one that, particularly in the South, but across this country, is very aligned. And this is one of the places where, notwithstanding the Civil Rights Act, the U.S. Supreme Court has created challenges to bringing about the full effect and intention behind the Civil Rights Act. So in cases much more recently, the United States Supreme Court has prohibited the use of race in trying to ensure fully integrated public school systems or quotas in making sure that kids enjoy socioeconomic and racially diverse learning atmospheres. The Title V created a commission on civil rights. It had been established, that kind of commission had been established in 1957, but this expanded on the work that it did to document problems and help bring about change. Title VI is a provision of the Civil Rights Act that I litigated under. And what it says is if you receive federal funding you are required to engage in non-discriminatory action. And if you engage in discriminatory action, you could lose access to your federal funding. So it's not just about necessarily prohibiting a certain conduct, it's like there's consequences for that conduct. And that economic incentive is one that has turned out to be very powerful. And so now it varies by administration, but there are ways in which most federal agencies work to ensure that state and local government that receive federal funding are using it in a non-discriminatory way, and there are mechanisms for community members if they see, this busing system in Ohio does not serve Black communities the way it should, for them to go to the Department of Transportation and say, we need a different process, we need to re-examine this decision of how these bus lines go. And that was one of the more recent Title VI complaints. Sadly, during the Obama administration, that was successful. Same thing, the Environmental Protection Agency has employees who are focused on making sure that environmental decisions are non-discriminatory, because a lot of local agencies receive federal funding with respect to protecting our environment. One other provision, there's two more provisions I'll mention. There's 11, but I'm not going to go into all of them. Title VII was about equal employment opportunity. And Title VII was a really important piece of the act that didn't go far enough. It required amending to make sure that we were, in fact, creating equal opportunities for everyone, regardless of race, but also that there were the kinds of enforcement mechanisms necessary to make sure that that happens. It's also one of the provisions that has, in the course of review and refinement by the United States Supreme Court, gotten a little limited. So this is one of those areas that we need to keep an eye on. It's true in the Voting Rights Act as well, but you can have great landmark civil rights legislation where Congress actually gets together and gets it done, and then you can have another branch of government chip away at it. The last provision I want to mention is about where civil rights cases got filed. So Title IX of the Civil Rights Act made it easier to move civil rights cases from state court to federal court. And I bring this up as a sitting state court judge to remind us of the pendulum that swings. In the 1960s, filing cases, civil rights cases in state court was a death knell, especially in the South. You would never get a justice-minded individual willing to listen to your case. So federal court was where you had at least some chance of getting a fair shake. Over time, that pendulum has swung. And there was a time that we saw people fighting for state courts, the appointments to the federal courts being lifetime appointments where you can't vote them out if they're doing a poor job, changed the makeup and the direction of the federal judiciary. And so we fought for our state courts, because in a lot of states we elect our state court judges. Not all of them, but some of them. And so I think we're in a moment of pendulum swinging again, and I'm not sure where it's swinging, except it is challenging in so many places for civil rights litigants to get a fair shake, to have someone listen to their case, listen to the facts and the law, and apply it without fear of what delivering equity means. And so we know that now we are in a position where judges on state and federal courts have to utter, or write in this case, but also utter, words like, "For fear of our democracy, I dissent," which is what Justice Sotomayor said yesterday. I say this to say two things. One is that Congress can always act. I'm not naive about the challenges that requires right now. But there is also still power at the ballot box. The reason we got the Civil Rights Act was because people bled, fought, and died for this piece of legislation and the promise it created, even if that promise right now is unfulfilled. I want us to leave today celebrating the anniversary, celebrating getting done this thing that people said could never get done because Democrats would forever lose the South. The South would rise up, and it was an incredible accomplishment to get this enacted, and I'm here to celebrate it.
Thank you so much to the library, to the event planners, the sponsors, my fellow panelists, and to each of you. We come here today talking about the second, in many ways, what C. Vann Woodward called the second Reconstruction. During the first Reconstruction, we saw many civil rights acts. There was the Civil Rights Act of 1866, which, among other things, gave citizens, all citizens, the right to make and enforce contracts and to participate on juries. This promise, thinking about this in terms of racial discrimination, this promise of the first Reconstruction, one might argue, has not been fulfilled. There were a number of civil rights acts to prohibit or to police white supremacist organizations, like the newly emergent Ku Klux Klan. There was a Civil Rights Act of 1875. The justice here talked about Title II and Title III of the Civil Rights Act of 1964. Title II, again, prohibited racial discrimination in public accommodations, hotels, motels, restaurants. In 1875, Congress passed a law which prohibited racial discrimination in public accommodations. That law was struck down in 1883, the Civil Rights Act, the Civil Rights Cases of 1883. And the Supreme Court in 1883 wrote, if we keep talking about the slavery question and the badges of servitude, how long will we run this question into the ground? This is only 18 years after slavery. Does this sound familiar today? Yes. And so Jim Crow persisted. Jim Crow developed and persisted. One of the kind of takeaway points is that no doubt Reconstruction was a moment of incredible racial progress. You had people who had been enslaved become legislators even just a couple of years later. That the state of South Carolina, for terms, lower house had a black majority. Can you imagine that? Right? The state of Mississippi had 2 black U.S. senators in just a couple of years. That has not been replicated. The question is, right, that we continually confront, right, in the master narrative around racial progress over time, things get better. To be sure, things may not be perfect now, but it's better than, let's say, in Jim Crow. And then our children will have necessarily, according to this narrative, a better or brighter racial future. That's absolutely not true. Racist backlash often follows racial progress. We see this with Reconstruction and then the rise of redemption in Jim Crow. The Civil Rights Movement, so moving into the 20th century, raised questions about America's commitment to democracy in profound ways. As the Cold War raged, many African-American veterans, for example, said, how can America talk about democracy abroad when it doesn't practice democracy at home? That these veterans had fought during World War II, and they had sacrificed their lives only to come back to Jim Crow. And then in the 1950s and 60s, as countries in Africa, Asia, Latin America got their independence, the United States was fighting with the Soviet Union for the hearts and minds of what people called at that time the Third World. Will these newly independent nations follow a U.S. path to, quote, modernization? A troubling term for our ears today. Will they follow, though, a U.S. path to modernization? Will they follow a Soviet route? Will they pursue a third route? And racism was America's Achilles heel. And so what civil rights activists began to do was to exploit that tension. They began to dramatize their plight, talking about this global context. The civil rights movement, a sort of takeaway point here, was never simply a domestic movement. It was always an international movement. And as delegates from newly independent nations flew to places like Washington, D.C., they found Jim Crow in Washington, D.C., segregated public accommodations, segregated housing. As they drove up and through Western Maryland, this is before the creation of Interstate 95, they went through Western Maryland. They found Jim Crow all over again when they wanted to stop for the restroom or to get food. As sit-ins piled up, think about 1960, in this area, February 1st, 1960, there are sit-ins in Greensboro. They soon spread to Chapel Hill and to Durham, the World Watch. As protests raged in places like Albany and Atlanta, the World Watch. As protests increased in Birmingham and nonviolent children were attacked by bruising fire hoses and police dogs, the World Watch. The Kennedy administration was not particularly interested in civil rights, but everyday people helped to create the context for political and legal change. And this international context spurred the Kennedy administration in 1963 to propose a civil rights bill. Civil rights was never simply a moral issue. It was always a foreign policy issue. We can talk more about this, but I want to think about my 3 minutes of time.
Thank you, James. And thank you to everyone who put this great program together. James asked me to talk about the role of the black media, and as you probably all know, there were several institutions in the black community that were key to the civil rights struggle, what's called the long black freedom struggle, even before the modern.
Hold the mic up.
Even before, is that better?
Yes.
Yeah.
Okay, even before 1954, 1955, with the Montgomery bus boycott, and prior to that, the Brown versus Board of Education decision. And so the black media has been spoken about less. People may know about the black church, about black colleges and black high schools, and other black schools. So I'm going to talk about the role of black media in this 20th century black freedom struggle, and particularly the role of Lewis Austin and the Carolina Times. And I do have a few PowerPoint slides that are behind me and on either wall there. I think this is to change the slides. Hopefully I can figure this out. I'll try it. Anyway, obviously there you see a picture of Lewis Austin reading his newspaper. I think that's from 1947. So the civil rights struggle and the black press played a critical role in the movement that led to the passage of the 1964 Civil Rights Act and, of course, the other civil rights legislation. In North Carolina, the most important black journalist from the 1920s to the 1970s was Lewis Austin, editor and publisher of the Carolina Times in Durham. In 1958, Dr. Martin Luther King Jr. called the black press, quote, the conscience of our nation. He said of the black press, quote, it has become angry for people who dare not express anger themselves. It has cried for Negroes when the hurt was so great that tears could not be shed. It has been a crusading press, and that crusade has, from its beginning in 1827, been the cry of freedom. In describing the role of the black press, Dr. King perfectly described the role played by Lewis Austin in the Carolina Times, which voiced the anger of Black Carolinians and turned that anger into action in a 40-year crusade for freedom. In 1927, Austin purchased the Carolina Times and provided a voice for the Black community during a time when white newspapers were the voice of white supremacy in the South. The young editor transformed the newspaper into a vital part of the Black freedom struggle in North Carolina. An extraordinarily outspoken and dynamic leader, Austin fearlessly attacked anyone, including prominent Blacks and whites, who stood in the way of freedom and equality for all people. He personified the Carolina Times motto, "The truth unbridled." This is a picture of the Carolina Theater. In the 1930s, Austin flouted Jim Crow law and bragged about it. On one occasion, he attended a concert at the racially segregated Carolina Theater in Durham with his wife and sister-in-law. Although Blacks were required to sit in the balcony, Austin disregarded the usher and sat in the main seating area, which was for whites only. After the concert, Austin publicly boasted that white people would never force him to sit in the buzzard roost with the so-called Uncle Tom leaders of the Negro race. During the 1930s, he also initiated a new strategy in the Black freedom struggle as he employed legal tactics and counseled African Americans to leave the Republican Party for the Democratic Party, a tactic designed to increase Black political influence in the one-party state. You may recall that African Americans had been Republicans since Reconstruction because the Republican Party was the party that supported the 13th, 14th, and 15th Amendments. Austin led voter registration drives, campaigned for public office, pursued integration of higher education in the courts, lobbied for equal pay for Black teachers and equal funding for Black schools, demanded economic opportunity for African Americans, and denounced police brutality. In 1933, Austin joined with attorneys Conrad Pearson and Cecil McCoy to bring the first lawsuit to challenge racial segregation in education in the South, when they filed suit on behalf of Thomas Raymond Hocutt, who sought admission to UNC Chapel Hill's pharmacy school. There's a photograph, three photographs. You see Thomas Raymond Hocutt on the left, who was the plaintiff who was applying to break the color line at UNC, and then attorneys Conrad Pearson and Cecil McCoy. The case did not succeed. They filed in state court, and it was thrown out of technicality, but it was the first and led to a series of cases, which of course eventually led to Brown in 1954. In fact, Conrad Pearson, one of the attorneys on the case, was a classmate of Thurgood Marshall's at Howard University Law School, which under the leadership of Dean Charles Hamilton Houston was becoming essentially a center for Black constitutional lawyers to challenge Jim Crow. And Marshall and the others law students at Howard studied the Hocutt case as a way to learn about what to do going forward. In 1935, just 2 years later, Austin co-founded the Durham Committee on Negro Affairs, which promoted Black political participation and worked to improve Black life in Durham. This organization still survives as the Durham Committee on the Affairs of Black People. Just one year before that, actually, in 1934, Austin was elected Justice of the Peace as a Democrat, a victory that was hailed by the Pittsburgh Courier as the beginning of the New Deal in the South. This was also during the first term of Franklin D. Roosevelt. During World War II, Austin was the leading North Carolina advocate for the Double V strategy, fighting for victory at home against racist injustice while supporting U.S. efforts against the Axis powers abroad. In doing so, he shined a bright light on the contrast between the U.S. government's wartime rhetoric of fighting for freedom in Europe and Asia, while acquiescing to or supporting the oppression of Blacks every day on the home front. He backed A. Philip Randolph's March on Washington movement in 1941, which compelled President Franklin D. Roosevelt to issue an executive order banning racial discrimination in defense plants. When white employers still refused to hire African Americans in defense plants, Austin wrote in the Carolina Times, calling them, quote, contemptible jackasses who were throttling this nation's effort to save our shores. The truth unbridled. He also denounced the U.S. Armed Forces' racially oppressive treatment of black soldiers as, quote, unsafe, unsound, and damnable. Despite being harassed by the FBI and the IRS, he refused to tone down his attacks on the U.S. and North Carolina governments for perpetuating racial injustice. Austin revitalized the Durham branch of the NAACP after a white bus driver murdered a black soldier named Booker T. Spicer in Durham in July 1944. The bus driver, who was exonerated by an all-white jury in just 28 minutes, shot PFC Spicely for defying Jim Crow seating on the bus. Austin wrote, quote, the humiliation under which the Negro is serving in the armed forces of his country, the bitter sting of segregation, the flagrant insults of those white people who have never been close enough to God Almighty, that out of one blood he created all people to dwell upon the face of the earth. All of these will never be able to crush the spirit which exists in the breast of the Negro. The post-war decade leading up to the Brown versus Board of Education decision was a critical era in the long black freedom struggle. In January of 1951, Austin told a Winston-Salem audience of African Americans celebrating the 88th anniversary of the Emancipation Proclamation, quote, our eternal goal must be equality. We will teach it and thunder it from the pulpit until every child achieves it. Working with the Durham Committee, Austin played a crucial role in increasing black voter registration. In 1945, this is 20 years before the Voting Rights Act, Austin mounted the first campaign of the 20th century by an African American to win a seat on the Durham City Council. Although he lost, his campaign laid the groundwork for subsequent runs by African Americans, leading to the election of the first black member of the Durham City Council in 1953, Rancher Harris. Austin fought for integrated public facilities. In 1947, he organized an integrated football game in Durham between a white team and a black team, which national newspapers pronounced the first racially integrated football game in the South. When North Carolina's white public officials voiced their opposition to civil rights, Austin was quick to denounce them, as he did in 1949, calling a speech by Senator Clyde Huey, quote, a long, asinine diatribe against Negroes, which was delivered to a white audience that, quote, pathetically rollicked and reveled in the slime of race baiting that befouled the air. During the 50s and 60s, Austin joined with a new generation of activists who fought for integration of public schools, lunch counters and restaurants, equal access to employment opportunities, and voting rights. Unlike many other black leaders in Durham, he immediately and enthusiastically embraced a sit-in at the Royal Ice Cream Parlor in Durham that began in 1957, 3 years before the more celebrated Greensboro lunch counter sit-ins. He advocated civil disobedience and direct action, publicizing sit-ins, boycotts, and marches, serving as an important advisor to young activists. After the Greensboro sit-in started in February of 1960, some of the young black activists at North Carolina College, now in North Carolina Central, went to talk to Lewis Austin and sought his advice about starting a sit-in in Durham at Woolworth's. And of course, Austin supported that. And they started that sit-in a week later, on February 8th. And I like to argue that that sit-in was incredibly important because if the Greensboro sit-in had been a standalone sit-in, it might not have catalyzed the movement. But by spreading it to Durham, into Raleigh, to other cities in North Carolina, and then throughout the South, it did lead to a much wider movement, which ultimately did lead to the Civil Rights Act. When white movie theaters defied or defended racial segregation, Austin called their comments, quote, weak, stupid, and about as asinine as any we have heard by so-called intelligent persons. He also backed a boycott of white retail businesses in Durham that refused to hire black workers by publishing the names of those businesses in the Carolina Times. This strategy proved quite effective in forcing white businesses to hire African-American workers. During these years, Austin worked relentlessly for public school integration as North Carolina government officials implemented policies to delay enforcement of the Brown decision. When Southern white conservatives cried out for states' rights in rejecting the Brown decision, Austin denounced their claim as a sham whose sole purpose was to perpetuate white supremacy. He spoke truth to power when he asserted that states' rights meant, quote, the right to compel Negroes to go to inferior schools. It means the rights to attack and rape Negro women. It means even the right to lynch, to force Negroes to enlist in the armed forces, to fight for democracy, and then deny them the fruits of their sacrifices. During the mid-1960s, Austin's efforts, along with those of thousands of freedom fighters, compelled the U.S. Congress to pass the Civil Rights Act of 1964 and the Voting Rights Act of 1965.
So we'll specifically be talking about Reverend Dr. Pauli Murray's contributions to the Civil Rights Act of 1964. I'm delighted to be holding space with all of you this morning. Justice Riggs, Dr. Lovelace, Professor Gershenhorn, thank you so much for your comments. Really appreciate them. If you all know of Pauli Murray, if you have heard that name, if this is somebody whose works you've read, give me a shout. Okay. Wonderful, that's a great place to start. So this is just an invitation to learn a bit more about the brilliant human being that was Reverend Dr. Pauli Murray, a Black, queer, gender nonconforming human rights activist during the 20th century. Pauli Murray was born in Baltimore in 1910, but moved to Durham when she was a child and was ultimately raised in Durham. And Pauli gave us nearly 75 years of life before passing away in 1985. And in that 75 years of life, Pauli Murray did so many things. She was expansive, and so today we are going to ground in Pauli's work as a Black feminist attorney and legal scholar. And due to this framing, I'll primarily be using she, her pronouns during my talk today. By the time that Pauli Murray turned 30, she had navigated an unconscionable amount of both race and sex-based discrimination. Some of those experiences were high profile, like being another person who tried to break the color line at UNC Chapel Hill. She was denied entry to study sociology as a graduate student at UNC Chapel Hill. I'll name that the NAACP thought that her case was a weak and would not take it on as a test case, unlike the case that we just heard before us. Some of Pauli Murray's experiences with discrimination were bitter pills that she swallowed every single day, like being ignored and ridiculed as a law student at Howard University School of Law, where she was the only woman in her law school class. In fact, as a 30-something-year-old law student, she coined the term Jane Crow to describe her experience facing discrimination as someone who was both Black and perceived to be a woman. Through Pauli's middle-aged years, her feminist consciousness evolved. She ultimately came to consider discrimination against Black women in particular as an issue that could help litigators and activists think in a more integrated way about achieving equality and citizenship, both socially and legally. Pauli was able to continue to sort out this theory when, in 1961, she was invited to serve on President John F. Kennedy's Commission on the Status of Women, on the Committee on Political and Civil Rights. Here, Pauli explored how to mitigate gender discrimination legally.
Polly also found herself engaged in the work of the civil rights movement at this time, but she ultimately distanced herself from the movement because of male leaders' treatment of Black women. So it's these concurrent realities that put Polly Murray in prime position to advocate for the 1964 Civil Rights Act, and specifically Title VII of that act, which you heard Justice Briggs reference earlier this morning. Now, when the bill was close to being passed, sex was kind of thrown in, included in Title VII as a protected category. And this scared a lot of people. Some people wanted to eliminate sex as a protected category in that title altogether. Other folks were concerned that the inclusion of sex as a protected category would ultimately compromise or torpedo the bill. So people were really freaked out about protecting women as a result of this bill. With this bill in a tenuous position, Polly Murray ultimately advocated that sex be included as a protected category in a 44-page memorandum of support that she ultimately circulated amongst lawmakers, policymakers, and advocates. Polly's brilliant advocacy via this sweeping memo helped to lead to the ultimate passage of the Civil Rights Act of 1964. And so I'm going to spend some time walking you through Polly's arguments that she mounted in this memo before we explore the enduring legacy of her legal theory and work centered on gender discrimination. So y'all ready to go on a journey with me? Yes? Okay, let's look at these arguments. So Polly's first argument in this memo is that historically, women's rights and civil rights have been parallel and interrelated movements. In this first argument, Murray challenged lawmakers to ultimately understand and be responsive to historical patterns. She notes that historically, struggles for the liberation of Black people and women have run concurrently, and that they're often intertwined. She argues further that this is part and parcel due to Black people and women's positionality in society. Ultimately, both of these groups' oppression is born out of patriarchy, which positions them as inferior groups that should not participate fully in society. In the memo, Murray writes, "It is no accident that revived national interest in the status of women has occurred at precisely the same moment in history that Negroes have shown unprecedented militancy and determination to achieve full participation in common life. Historically, women and Negroes have held strikingly similar positions in American society and have carried on interrelated struggles to achieve full citizenship." So again, she is challenging lawmakers. Pay attention to history. Polly's second argument reads that failure to recognize the interrelation of human rights has had tragic consequences in United States history. Once again, Polly Murray, through this argument, is challenging lawmakers' framing or understanding of history. She is saying that including sex, or really the Civil Rights Act as a whole, and specifically this Title VII, is not a Black issue. It's not a woman's issue. Ensuring that these groups are enfranchised is simply a human rights issue. She cautions lawmakers not to protect the rights of one group at the expense of excluding another. Again, Murray writes, "The costly lesson of American history is that human rights are indivisible. They cannot be affirmed for one social group and ignored in the case of another without tragic consequences. Whenever political expediency has dictated that the recognition of basic human rights be postponed, the resulting dissension and conflict has been aggravated. Time and again, this lesson has been driven home to us, and that's a message that resonates with me today. Ultimately, Murray argues that including women explicitly in this legislation vis-a-vis sex ensures that everyone is protected and that everyone's rights are recognized. Pauley's third argument reads, the employment rights of all must be protected, or the rights of none will be secure. Ultimately, this is one of Murray's more complex arguments, but it boils down to this point, that protecting women in the labor force will ultimately create a pathway for protecting all workers. She also notes that including sex in Title VII will presumably reduce barriers for women's participation in the workforce. And at the time that Murray is writing this memo, women make up 1/3 of the labor force. And she notes that we need more women in our labor force for our economy to survive. And so again, including this provision benefits the labor force ultimately. Pauley's fourth argument reads, the inclusion of the sex amendment is necessary to protect Negro women. Some folks were concerned that including a sex clause in Title VII of the Civil Rights Act of 1964 would exclude white women from employment, with preference given to Black women and Black men. But Pauley ultimately here is reframing this concern, arguing that without the sex clause, Black and white women will, quote, share a common fate of discrimination. With the sex clause, Pauley posits, they are both likely to be included in the labor force. Simply put, this clause is a pathway towards a more inclusive workforce. Pauley also drills down on her arguments further, naming that Black women generally have less of a social safety net, and they need to work. They're more likely at this time to be providers for their families. So they're more vulnerable generally, and more vulnerable when seeking employment in the workforce. And so again, this clause really provides more of a net that Black women need. Black women who need to work need. Murray writes, the Negro woman must be prepared to support herself and others for a considerable period of her life. For her, therefore, if civil rights legislation is to be effective, it must of necessity include protection against discrimination in employment by reason of sex. Pauley's fifth argument reads, the sex amendment will help effectuate equal pay legislation. I'll read Pauley's argument directly from the memo because it's so concisely and brilliantly stated. Pauley argues, if the national policy of equal pay for comparable work is to be effectuated, it must be buttressed by legislation which prevents discrimination at the initial or hiring stage of employment of women. And that is something that I think is a promise that is still yet to be realized, especially when we're talking and thinking about equal pay. But again, this is the bridge that Pauley is building to legislators, policymakers, and advocates to help them think about why sex absolutely must be included as a protected category in Title VII of the 1964 Civil Rights Act. And ultimately, these arguments help see the bill through to success. I'll name that these seeds that Pauley planted bore even more fruit and had long-standing impact that we're bearing witness to even in recent years. I'm going to talk to you through some of that fruit. In 1965, at the age of 55, Pauley Murray became the first Black person to graduate with a doctorate of law from Yale Law School. So I'll be referring to Pauley Murray as Dr. Murray for the remainder of my talk. Dr. Murray continued to strengthen the theories that she put forth in that 1964 memo, and ultimately this work resulted in an article titled Jane Crow and Law, Sex Discrimination in Title VII, which she co-authored with attorney Mary O. Eastwood in December 1965 for the George Washington Law Review. Murray and Eastwood argued that Title VII and the Equal Protection Clause of the 14th Amendment should be applied to prohibit discrimination against women. Ruth Bader Ginsburg later relied on this theory to successfully litigate Reed versus Reed, a landmark gender rights case that recognized sex discrimination as unconstitutional at the Supreme Court level. As recently as 2020, the foundation of Murray and Eastwood's work and theory have been used to protect LGBTQ+ people in the workplace at the Supreme Court level, furthering legal protections for members of the LGBTQIA+ community. I'll also offer, as Justice Riggs stated earlier, the 1964 Act, the Civil Rights Act, did not fulfill all its promises. After it was passed, the body responsible for enforcing the Act, the Equal Opportunity Employment Commission, ultimately failed to enforce that sex clause in Title VII. This really frustrated Pauli Murray, and she ultimately advocated alongside a network of feminists for a civil rights organization for women to make sure that clauses like sex in Title VII and other women's rights measures were enforced. She wanted to make sure that women were enfranchised at this period due to this failure. It's that advocacy that ultimately resulted in the establishment of the National Organization for Women, which Pauli Murray helped to found in 1966. So, as I've stated, and as you all have learned today on this journey, Reverend Dr. Pauli Murray was so much: an activist, a thought leader, a legal theorist, but most remarkable of all, I argue, an architect. It is amazing that we are still benefiting from their groundwork in the 2020s, groundwork that was catalyzed by the complicated realities of the 1964 Civil Rights Act. Thank you.
Thank you.
Yeah, no, thanks for that, Jay. I appreciate you saying that. I was going to take my time no matter what. I appreciate you looking out for me. I'm going to get my time. This has been amazing, and I'm really, really grateful to be here. Gosh, I learned so much from you. This is really, really remarkable. Okay, so thanks for that setup. I want to take a couple of steps back, and I'll be engaged a little bit with Robert Derrick. This has been really, really remarkable. So, I love to mention about FDR, right, the New Deal, right, and the idea of federal workers, right, and both of those also was really remarkable. And so it's totally right. But really, that was like the beginning of many black starting to align with the Democratic Party was the New Deal. And then we fast forward to 1948, thinking about Harry Truman and desegregating the armed forces. And then that same year, Strom Thurmond running as a Dixiecrat for president, right? In direct response to Truman advocating for black civil rights, saying no, he doesn't stand for that. And so it was very much rooted in white supremacy, racism, and being upset with advocating for black civil rights. I want to talk a little bit about 1960, and it's really interesting that we're all kind of sitting here together, so just bear with me, good people. So one of my favorite things to show students in the classroom is something called the living room candidate. They have all the ads going back to 1952. Adlai Stevenson, right? And it's, wow, if you just want sort of a sense of what the world was like in a given year, it's amazing, like the moving image, it's free, just go there sometime and just listen to these ads. So the 1960 election, You pitted Richard Nixon against John F. Kennedy, okay? And they both were talking about civil rights. And so can I tell you, Dr. Lovelace, I want to give people time to, I mean, we're all peers. No, anyway, I want to be respectful. But, so I want to build on that point, Professor Lovelace made, which is the idea of civil rights being more of a foreign policy issue. Okay, so if you look at these ads, and you all can fact check me on this. Let's start with Richard Nixon. I'm not going to act like I'm Nixon. That would be a little odd, right? But just act as if I was sitting on this table in front of you like this. And I want to talk to you today about civil rights. I don't have a good Richard Milhouse Nixon. I got to work on that with the child. I got to work on my impersonation. But he wants to talk about civil rights. He was talking about it from a foreign policy perspective in terms of the war, right? Exactly what Professor Lovelace said. Wasn't about the innate dignity and rights of black people. Sorry, I said black people. Let me hold it. It wasn't about that. It was about communism. It was about us not looking good on the world stage. This guy was the vice president of Eisenhower, who sent the troops into Little Rock High School, right, Central High School, in Little Rock in 1957. Okay? The Civil Rights Act in 1957 was passed. So there were things that Eisenhower did in the realm of civil rights. Nixon, and in fact, Nixon says in his ad, though, that more's been done for civil rights in the last 8 years than I think he said the previous 80 or something like that. Okay? But he talks about that. Right? But instead of just saying, hey, we've done a lot for civil rights as the Republican Party in the United States, he frames it as a foreign policy issue in our fight against communism. Okay? Contrast that with JFK, okay? He's sitting, just like I'm sitting here with this great panel, and Harry Belafonte is in his ad. Okay? He's sitting across from him, and it's almost like this is between the two of us, right? Again, you're all smart people, but right, this is 1960. This is before the Civil Rights Act. This is before someone being able to go into Sutton's or Gruber's Bagels and I don't know if Gruber's existed. 83, that's the year I was. So Sutton's was around, right? Carolina Hills, a great restaurant on Franklin Street. Being able to sit across from someone who's of a different racial group in New York. A white person and a black person having a meal together. These two guys on an ad as part of a presidential campaign, they're talking with each other. And Kennedy talks about wanting to do something on behalf of black people. And so, and granted, he didn't want to, I don't want to act as if Kennedy was a savior, but in his ad, right, he's seated with Harry Belafonte. And they are seen as equal. He's not standing above him, right? He's sitting next to this guy and bringing him into the conversation, okay? He kind of has his legs crossed. And Kennedy was smooth operator, right? So it's true to form, okay? Now, this was already noted. Not a whole lot was done, okay? It wasn't until June 11, 1963 that Kennedy gives his address, right? And they weren't necessarily enamored with all that was going on in the South, okay? Eventually, RFK kind of had this kind of change of heart, and so he runs to 68. I think he really did have more of a change of heart even than his brother did. And he said, like, I was reading a book about John Lewis, and he said, like, the movement helped him see the world in a different way. But I digress. Okay. So back to 1964. So Kennedy is assassinated in November of 1963 in Dallas, Texas. LBJ becomes president. And then in that year, the Civil Rights Act is passed, right? That's why we're here. So the 1964 election, I want to talk a little bit about, okay? Let's have maybe a little audience participation. This is what I love being a professor. You're all smart people, so we can have a little fun with this, okay? But 1964, okay? Barry Goldwater is a Republican candidate. He's one of the senators that votes against the Civil Rights Act. And so, James, just to make sure I get to answer your question or build on your point, the senators from North Carolina at the time, I believe they were Irvine and Jordan, they were opposed to the Civil Rights Act. I think Irvine in particular. So there was filibustering. There was the stalling of the passage of this act. There was resistance to the Civil Rights Act. And it was a regional resistance. It wasn't Democrat-Republican. It was Southern versus non-Southern. Okay? So that was oftentimes we think, oh, everything's about partisanship. No, it was really about region. All right, we also had probably had liberal Republicans back then. It seems like that was another time, right? I mean, I didn't live there at that time. Y'all tell me about what that was like. Maybe after the panel. Can you tell me? Yeah, what's a liberal? Anyway, I digress. Okay, so here's my point. So, Goldwater opposes it, okay? And so, Johnson wins in a landslide, and he just wipes the floor with Barry Goldwater, okay? Although, Goldwater, in the Deep South in particular, actually does quite well, all right? So, here's my takeaway point before I have a little audience participation with you all, okay? The argument I want to make, and it's just what other people have said too, it's not my argument, but what the data show is that 1964 was a turning point. At that point onwards, from that point onwards, blacks were aligned with the Democratic Party. In part, well, because it was a party of civil rights. We get a choice between the party that's gonna be in support of the Civil Rights Act and one that opposes it, right, logically, right, strategically, you're gonna vote for the party that supports you, okay? And supports your civil rights. And so from that point on, you see strong support among blacks, all right? Blacks being aligned with the Democratic Party. I also think, I heard a really smart scholar say this, so I'm gonna quote him, that was the last time a majority of whites voted for a Democratic presidential candidate. Oh, sad, we'll let that sit for a little bit. Now, I'm not saying it's about you all specifically, right? That's in the aggregate. I'm having too much fun here. Okay, so 1964, all right? Democrats is the party of civil rights. So you all, let's go through time here. You all feel free to chime in with me, okay? So 68, all right? Nixon comes back, he wins. I mean, all hell broke loose. Oh, sorry, I'm sorry. A lot of the Democratic convention was difficult. I was the first person to cuss. Well, no, he said asinine, and then we quoted him, so I think it was a difficult Democratic convention, right? Johnson doesn't run, Nixon, Humphrey's the Democratic nominee, okay? So Nixon wins, okay? So a Republican win. This is sort of my point. You all just bear with me, okay? 72, Nixon, right? No, you can jump in. So Nixon wins, right? Same guy, Republican, all right? So 76 was a little different. Nixon had to resign. What's the church thing? I get what I'm saying is. It's hot in here. I feel like I'm on the mic, so I'm preaching here. So 76, all right, Jimmy Carter, he wins, right? It's a close election, though, all right? So a Democrat wins, a Southern Democrat, okay? So you all can tell me, well, what happened in the 1980s? Did a Democratic presidential candidate win in the 1980s? The answer is no. Thank you. I should have waited for it. That's exactly right, all right? Reagan beats Carter, who's an incumbent, all right? 84, he wins his re-election, just destroys Mondale, okay? In 88, Dukakis, you know Jesse Jackson was in the mix. We can talk about Jesse later if you like, right? But Dukakis gets the nomination, and the elder Bush beats him, okay? And so that really ushered in, so if we go through, let's go very quickly here. So right, Republican wins since 1964 is my point, right? 68, 72, 80, 84, 88. It shifted dynamics in this country. Once the Democratic Party became associated with the Party of Civil Rights, you ushered in this era of Republicans doing well, the backlash, okay? To something as simple as allowing people to be able to access public accommodations and get equal right to funding, all justice resources. So I could keep going here, but let me just end by saying, that's been about 10 minutes, I took my time. So Bill Clinton really ushered in this new wave, this third wave of a more moderate Democratic Party that then President Obama inherited, and that's where we find ourselves today. And that's why so many people are opposed to like President Biden. Biden, Obama, Clinton are all like that kind of center left, more moderate Democrat as opposed to like a much more progressive Democrat. And it's in part because of how the political landscape has changed in this country, where it's been much more of a movement towards conservatism, in part because of backlash for civil rights. So thank you all.